everyone. My name is Kate Kozikowski. I am a real estate agent with Right at Home Realty Brokerage, and I am a top producer in my branch. And today I have a pleasure to meet one of the best real estate lawyers in Toronto and one of the greatest litigation lawyers. And hello, Greg. Can you
Hi
tell
there.
us a little bit about yourself, your practice?
Yeah, sure. Thanks, Kate. Name's Greg Whedon, principal lawyer, Whedon Law. I do, practice predominantly real estate-based litigation. We have a busy real estate conveyancing firm here as well. So we do pretty much everything from beginning to end. And if a transaction goes south, then I jump in and litigate that in court. We've been working with Kate for a number of years now. It's actually the first time that we've actually met face to face. COVID obviously played a role in that, but it's a pleasure. Thanks for having me here.
Thank you. Most of the questions my clients ask are, first of all, why do we need a lawyer in a real estate transaction?
Okay, well,
And what's your role?
that's a loaded question, but I'll try to summarize that as best as possible. Why do we need a lawyer? Well, the rules say you need two lawyers to do a real estate transaction in Ontario. That's the short answer. That's the easy answer. But the real reason is that there's a lot of these properties are worth millions of dollars these days. A lot of hard-earned money is going into these transactions, and a lot of due diligence needs to be done. Behind the scenes title searching, making sure the parties are well represented with competent solicitors, from beginning to end. And these transactions these days are not easy. There's always problems these days, whether it's financing problems or defects on title. There's just no other way to deal with those issues without an experienced real estate lawyer on the conveyancing side. And they help you from the beginning to the end, from getting the file in, reviewing the agreement for you, or status certificate, which I'm sure we're going to talk about later on, providing you advice on that. And then once the agreement's done, once the realtors have firmed up the deal, then they pass the torch over to the lawyers, and we work behind the scenes, do the title searching, meet with the clients, make sure that the clients are who they say they are, which is another big problem that we're dealing with these days with a lot of fraud. And then we work with the other lawyer on the other side and make sure that you, as the buyer or the seller, but as the buyer, get clear title and you get what you bargained for. And that's the nature of the game pretty much, and the stakes are high. So you just need to make sure that you have competent real estate counsel.
Yes, and like you said, a lot of money on stake, and a lot of problems these days,
Lots of problems.
right? Especially with the market change and appraisal going, too high. And yes, as you know, I deal with a lot of condos and condominium transactions. Can you tell me about status certificate? What is it? And what special attention you pay reviewing status?
So the stat certificate is it's an overhead view of the corporate and legal status of a building, of a condominium. It is a corporation. The condominium structure is a corporation, and there's a printout at a point in time of what the health and the status of that building is. So definitely the most important document to review, like either before or after, during the transaction, the agreement of purchase and sale is signed. The lawyer will review that document. Some lawyers don't review it well. Other lawyers do. It's very important that it's done properly.
We know that.
Yeah. At the end of the day, the important parts of that certificate, are the legal, any disclosure of any legal claims against the building. Sometimes there's, $1 million lawsuits from like elevator companies or developers going bankrupt and construction liens, lots of different types of litigation litigation attached to these buildings, even slip and fall, something like that.
Special assessments.
And then, yeah, the result of that litigation can be, 5, 10, $15 million. And, the buyer needs to make sure that they know, what the consequences of a lawsuit would be if the corporation lost that lawsuit. So that's one of the things that we look for in a status certificate, any disclosed legal proceedings. Another obviously would be on the financial side, whether or not the budget's up to date, whether or not the the reserve fund is healthy. Those are really financial questions for the accountants. But at the end of the day, we'll see red flags there. If they're running deficits, then it's clearly not being run properly. So we bring that to the client's attention. There's various other things as well. If there's unpaid common expenses, that's obviously going to be a lien on the property. So there's a bunch of different things that could be wrong with that certificate. So it's very important that a lawyer takes a look at it before the deal's firmed up, and then that's how we proceed after that. But that's definitely the most important role in a transaction from the outset for a condominium, for sure.
So another question I get asked a lot is about assignments. As we know, assignments are very popular. Now the market's kind of soft for them. But what do you look when checking assignment contracts? What, can you tell about what is assignment, first of all?
Yeah, an assignment would be essentially there would be two parties. There would be a buyer and a seller. They would enter into an agreement of purchase and sale, whether or not it's for a new development or a condo or a home, and then the buyer would look to assign the contract to another buyer. So another buyer would step into the shoes of the original buyer and take over the agreement. That's what an assignment is. Before closing, yeah. So it can happen on the seller side too. A seller can assign it as well. But most likely, there's a market that you're familiar with for buyer assignments, generally condos. Generally condominiums. So what we would look for would be we would take a look at the original agreement with the builder, and we would see whether or not there is an assignment available, right? Because do they allow it? Most builders don't allow it, or if they do, they charge you $5,000 or $10,000 to do it. Builders definitely don't like people assigning because they're making money off before it closes. It's being flipped 2 or 3 times. And they just don't like that. It's bad for business. But as long as they make money in the process, they're happy with it. And then, what else do we look for? Make sure that all the deposits were paid properly to the builder. That, the structure of the payment for the closing of the assignment is correct. Oftentimes, the profits on the assignment are paid at the final closing. Sometimes they're paid in advance when the builder consents to the deal. So that's important because sometimes you have to come up with a few $100,000 in profits before it closes finally with the builder, and people usually use mortgages for that much money, so they might not have that much money on hand. So at the end of the day, that's an important part for a buyer.
Sorry to interrupt, but on assignment, can you get mortgage? Can you do you allow to get mortgage, or you can get the mortgage only?
You can only get the mortgage when the building closes and registers at the end of the day. So the final closing between the builder and the buyer or the assignee. So you can't get a mortgage when you're closing your assignment in advance, because there's nothing legal to put a mortgage on. There's no title yet.
You have to have lots of cash, pretty much.
You have to have cash, or you structure the assignment to have all the profits are paid at the final closing, and then you pay the builder 75%, and then you pay the assignor the rest, the profits.
And there is also issue with the capping
development fees, or that's a big thing as well. That would be done when the builder and the original buyer negotiate the deal. These days, capping is very important. Development levies are increasing every year, and sometimes we're seeing $50,000 to $100,000 in development levies. Which the buyer's going to have to come up with right at the last minute. So a lot of deals are failing because of it.
Can you discuss the importance of title insurance when buying a property in Ontario?
Yeah, title insurance is very important these days. It protects against a number of different problems, namely with respect to title defects. That's what title insurance is for. Protects the marketability of the property. Very briefly, it protects against fraud. Most policies will protect against fraud as well. So if these days there's a huge issue with owners going into or sellers going into a lawyer's office and faking IDs and not actually being the owners of these properties, and then a new buyer will get title insurance, they'll get a mortgage, they'll close the deal, they'll move into these homes, and then the actual owners will show up after their vacation, and come home, and there's people already sitting at the dinner table. So title insurance in these situations will protect the buyer and the bank as well from that situation. Generally, they'll pay them out. Generally, the buyer who buys the property in good faith is a bona fide purchaser and will keep that property. But title insurance will move in and pay out the necessary parties and cover the cost of litigation. So that alone, that risk alone is worth it. Just because you can't protect, the lawyers cannot be held responsible for somebody faking a really good ID and going down that process. So that's just one area. Another area would be cottages, septic tank problems, permit issues, anything that's off title that generally wouldn't be searched by the lawyers these days. Title insurance will come in and they'll remedy it. So it's very, very important. Every bank is going to require you, if you want to use a mortgage, to get title insurance. We only do deals with title insurance, so it's.
Do you have clients which don't want to purchase?
Yeah, there are, but by the time we go through, the cost benefit of getting title insurance, it change your mind. Because if you don't get title insurance, then we have to do, thousands of dollars in searches, which the cost of title insurance is less than $1,000. So it doesn't make sense. Title insurance saves you money at the end of the day, so it makes the most sense to use.
There is a lot of fraud in regard to misrepresentation, and how the buyer or the seller can protect themselves these days. It was a huge topic on CBC, right?
Yes. You mean like title fraud, you mean?
Yes. And now, I will come to you and, pretended that I am the seller.
Right.
And,
right. Yeah. Look, it's a huge problem. It's always been a problem. Okay. So there's more media coverage over it for sure. And, with COVID, lawyers are meeting with their clients over Zoom. There's more chance, to have, a fraudulent purchaser or seller come into your office because they're not actually coming into your office. You can't see them. You can't touch them. You can't touch the ID. So it's hard to, there's more avenues for fraud to come into a transaction. How can they protect themselves? Title insurance would be number one. At the end of the day, just make sure you have a good lawyer that does the due diligence that they should be doing. And then that would presumably and hopefully, alleviate any potential fraud. But that would be the best case scenario, is just use title insurance.
So when I meet, for example, a client for the first time, a seller, how can I know that, he's a fake one? I check usually the IDs. I usually ask for 2 pieces of IDs, like driving license and other government issues IDs. But, these days, they can be really good scammers.
And there are, trust me, there's a lot of money on the line here, and a lot of money goes into these frauds, and they're generally pretty experienced. The same fraudsters will do it over and over again, so they'll have experience. So what we can do these days is take a look at the ID. There's ID check programs now that have come out where you can fill in the details. You can take a picture of it, send it to the program, the company, and they'll run the verification and make sure all the barcodes line up with the identification on the actual card. But at the end of the day, there's a dual method check. You check both government IDs, make sure everything kind of lines up. And then there's third-party companies as well that lawyers are going to have to start using pretty soon. The Law Society requires us to use them at the beginning of next year, a third-party identification system, which will verify, their ID. And then even title insurance, they also provide that service too. I know Chicago Title does. They will independently call the buyer or the seller, and they'll ask them random questions on their credit report to see if they pass or they fail. So I've had a few people fail just because they don't know their own information. But yeah, at the end of the day, it's a third party check that would be the best case scenario. But just use your own judgment. If you have a situation where it feels wrong, there's something probably wrong with it.
Very common question I get asked from clients regarding process of transferring ownership of a property through a will or probate.
Right.
Can you explain the differences? And I know these days when you wait for the probate, it takes, like you said, up to a year.
Yeah, exactly. So when you own a property on, when you're on title to a property, and that person passes away, if they're the only person on title, or if they hold title by way of tenants in common, then you can't disperse of that person's interest on title without going through the court and without probating the will. If there's no will, you still have to probate. So you have to get a court order, giving the person, the executor, or next in line, next in kin, the authority to transfer that property. So probating a will these days, in Toronto, it could take up to a year. Generally, it's supposed to be 4 to 6 months, but during COVID, there's a lot of backlog. There's not that many people in the court office in that department that are servicing probating right now. So it's taking a long time. So I would make sure to speak to a lawyer before you enter into an agreement to sell your property if there's a probate issue. Otherwise, you might default on that agreement because you can't do anything with the property. But that goes in, I think, into the next question about the how do you hold property and title? How do you hold title? There's two ways to hold title. There's joint tenants and tenants in common. Joint tenants is essentially two people or more than two people. They own the property jointly together. There's no divided interest. It's an undivided interest in land. So if there's two people, it's not 50-50. It's just you guys own that together, just like a joint bank account. You own that bank account together. If one party passes away, then the interest in that property goes to the other person automatically. So that's just how it goes. It's a natural flow of interest transfer. Whereas tenants in common, the other side, joint tenants and tenants in common, you have a divided interest. So on title, you'll see 20%, 80%, or 50-50, or 99-1, right? You'll see the actual interest being divided.
Or investment partners.
Or investment partners will probably always hold as tenants in common, just because naturally, if one of the partners dies, then the other partner doesn't get it. The interest in the estate, it goes into the estate. It goes to the spouse or the children, and into the will. So that's the important factor there. And if one person dies, then you have to probate that will to be able to transfer that interest to somebody else. So it goes hand in hand. So how you hold title is very, very important. Definitely get legal advice with respect to the differences between the two ways to hold title.
So when you buy a property, when you initially talk to the lawyer, you can tell him, or he can advise you which way to set up the title, right?
Yeah. I generally will, I'll give my opinion on how I think they should hold title. But you need to make that call, like when you're about to close the deal. We need to register that title, register your interest on title somehow. So generally, if it's a married couple or if it's estate planning, for example, then we would recommend joint tenant. But if it's an investment or with unrelated parties, then I would recommend tenants in common. But it all depends on the different situation, the different facts.
What about if, let's, for example, parents helping child and
Yeah.
we have to be put on a mortgage? Are they?
Yeah, that it depends on the situation. Like so you're saying that if when parents like let's say like the children are buying a home, they can't qualify, so they need a parent to come on title.
Yes.
So in that situation, it all depends. Like most often it will be 99% for children, 1% for the parent or parents. But it all really depends on how they want to structure it, and how close they are with the family, and how much money the parents are putting into the property as well. That obviously has a big factor as well, for various different reasons. So it all depends, but most definitely, you should talk to a lawyer about it for sure.
Yes.
Yeah.